I'm back. It's 9:45 p.m. now. Still Friday, March 14th, 2025, and it's nighttime. New docket dropped. So there's the full moon from the other night, looking more like the sun, I guess. And you can see, oh, it's 10 p.m. Get my lips ready for some reading. This is case 124CV 10049LJL, document 127, filed today, March 14th, 2025, 36 pages. This is page 1, United States District Court, Southern District of New York. All right, let's get into it. Blake Lively, the plaintiff, versus Wayfarer Studios, LLC. Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Melissa Nathan, The Agency Group PR, LLC, Jennifer A. Bell, and I'm already tired, and I haven't even started. Okay. And I feel like I'm going to want to take this off because I'm getting warm. So, Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, It Ends With Us movie, Melissa Nathan, Jennifer Abel, Steve Sarowitz as plaintiffs because it's a combined, versus Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR Inc., and the New York Times Company. So we're just going to have half on. Okay, let's go. Consolidated Plaintiffs' Memorandum of Law in opposition to Consolidated Defendant, the New York Times Company motion to dismiss the amended complaint. Okay, page 2. Consolidated Plaintiffs Wayfarer respectfully submitted this memorandum of law in opposition to the motion filed by Consolidated Defendant, the New York Times, to dismiss the first amended complaint, the fact, for failure to claim pursuant to Fed R. Civ P. 12B6, the motion. And I'm not going to read all that table of contents. Let's just get to the heart of it. And just like that, we're on page 11. A pietistic bastion of the media establishment.
Pietistic.
Pietistic.
Pietistic. Pietistic.
Of or relating to pietism or pietism. Of or relating to religious devotion or devout persons, marked by overly sentimental or emotional devotion to religion.
Pietistically.
Pietistically. So let's see, what the hell is it talking about? A pietistic bastion of the media establishment. The New York Times has long presumed itself beyond accountability. Not here. And what's a bastion?
Bastion.
Bastion, a projecting part of a fortification. Stronghold, a fortified area or position.
Bastioned.
Bastioned, a structure or place from which one can resist attack. There you go. They think they can resist attack. Okay, can't even get through the first 3 fucking words. All right. A pietistic bastion of the media establishment, the New York Times has long presumed itself beyond accountability. Don't throw your arm up like that anymore. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's California Civil Rights Department complaint, CRD complaint, and actively vouched for the veracity of its false narrative. The fair reporting privilege the New York Times seeks to hide behind does not protect it from liability for malicious colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfarer parties, wrongly casting them as villains and making them scapegoats for Lively's well-publicized media missteps. On December 21st, 2024, the New York Times published a story titled, "We Can Bury Anyone Inside a Hollywood Smear Machine. Why are there balloons? We can bury anyone." ECF number 107-1, the article, and a related video, the video, featuring New York Times journalist Megan Toohey, who co-wrote the article along with Mike McIntyre and Julie Tate, purporting to tell the world what really happened. Specifically, that the Wayfarer parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni, all right, maybe I'll take the shirt all the way up, going all the way up. Okay, what really happened? Specifically, that the Wayfarer parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath, quote, engaged in misconduct while shooting the film, end quote. The article and video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfarer parties, and falsely accused them of having waged a smear campaign against Lively. The press enjoys the fair report privilege when faithfully relaying the contents of a filed complaint, but that is not what the New York Times did. It admittedly based its article and video on its reporter's review of, quote, thousands of pages of documents, and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation. In doing so, the New York Times forfeited their fair report privilege. The New York Times prepared its salacious article and video well before Toohey contacted the Wayfarer parties the night before publication for, quote, fact-checking. This is the top of page 12 now. The night before publication for fact-checking, after the New York Times months of plotting with the Lively parties, the Wayfarer parties got hours to respond, but these hours included the hours over the night while they were supposed to be sleeping. The New York Times complains of group pleading, quote, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it's premature to require the Wayfarer parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties. That's what I was thinking. Like, they're basically acting as if they're supposed to have every single shred of evidence out already, like every single thing that would prove who did what exactly. They're not going to put that in their initial complaint. That's for trial. Of course, it's premature to require the Wayfarer parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties. A jury will determine the truth based on the evidence, but the Wayfarer parties' allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfarer parties suffer damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California, which has the strongest interest in protecting its citizens. Yeah, like, what is she fucking talking about? Besides, she originally filed a complaint in California. The New York Times article published less than 24 hours later. The New York bring claims under the law of California, which has a strong interest in protecting its citizens. The New York-based NYT insists it's entitled to New York law no matter where their harm was felt. But California law remedies harms suffered in California by California residents. I will take another little break on my eyes. Under either California or New York law, the Wayfarer parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends, I'm going to just maybe leave it here at the front of each row I'm reading. The New York Times contends that the article and video merely reported, quote, facts, and thus the New York Times is shielded by the fair report privilege. Yet, in the same breath, the New York Times also insists that its defamatory statements are not factual at all, but rather hyperbolic. Hyperbolic, non-actionable opinion. Neither theory holds up. The fact also states claims for false light, promissory fraud, and breach of implied in fact contract. Even if the motion is granted, it should be granted only with leave to amend. Federal courts apply an extremely liberal policy of amendment under Federal Rule of Civil Procedure 15. The Wayfarer party's claims against the New York Times are well grounded in fact and law. In addition, based on their own continued investigation and on facts drawn to their attention, the Wayfarer parties have obtained additional information since filing the fact that would enable them to plead further facts in support of their claims. This dispute should be resolved by a jury by trial. And then we'll go over here and we'll read the footnote. All right, up to the footnote number 1. While the New York Times baselessly claims in the motion that the facts allegations regarding the metadata associated with the article and video are, quote, wrong, ECF number 106 at 17 and 16, a Rule 12b6 motion to dismiss is not a proper venue to raise factual disputes. The New York Times does this repeatedly throughout this motion. Now we're at page 13 of 36, relevant background. And again, to save my hands from pain, I will just put the cursor at the front of the line that I'm reading. Wayfarer acquired the film's rights to Colleen Hoover's novel It Ends With Us in 2019, Fact 22. Justin Baldoni took on the role of director as well as male lead character Ryle, Fact 23. On December 31st, 2022, Lively agreed to take on the lead role of Lily Bloom, Fact 27. So, like three whole fucking years later, she came on. 3 years later. So 3 years later, wow. It initially appeared that Baldoni and Lively would have a productive working relationship as they collaborated closely in the production's early days, e.g. Fact 28 to 30. However, Lively soon began intruding into the production in ways well beyond the scope of her contractual entitlements. Fact 31. At one point, Lively issued an ultimatum that if Baldoni could not get on board with her work methods, he may have to recast her role, and motherfucking damn it, too bad he didn't. Fact 51. On November 9th, 2023, almost a year later, a year later after she signed on,
4 years into the project,
Lively's lawyer sent an unexpected and confusing 17-point list of non-negotiable demands that had to be met before Lively would return to work following the SAG-AFTRA strike, apparently drafted for the purpose of falsely insinuating that Baldoni, Heath, and others had engaged in sexually inappropriate conduct during filming. Fact 75. While the Wayfarer parties disputed that Lively's demands had any legitimate predicate, they nevertheless found the requests largely unobjectionable, which was another fucking mistake, and generally consistent with the existing practices, e.g. Fact 76 to 122. Filming proceeded thereafter uneventfully through the second phase of production without any further purported incidents of which Lively could complain. Fact 132. However, Lively exploited her carefully constructed paper trail of false insinuations. However, Lively exploited her carefully constructed paper trail, which is making me think of construction paper, constructed paper trail of false insinuations to complete a hostile takeover. I'm living in the middle of a hostile takeover of the film, based on the implicit threat that she would ruin the Wayfarer parties' careers and reputations. She was going to ruin them, their careers and their reputation. And motherfucking she did. Now, feels good to squeeze it because it hurts. Fact 133. Gradually, Lively took over the film's editing, ultimately extorting Sony and Wayfarer into releasing her cut, despite its poor performance in audience tests. End of page 13. Top of it, page 14 of 36. Fact 134 to 146. She also dictated the film's marketing, erasing Baldoni and driving a light-hearted, frothy, self-involved self-promotional campaign, which resulted in harsh blowback from the press and the public, who viewed Lively's marketing as tacky and tone deaf. Fact 147 to 149, 179 to 186. As the premiere of the film approached, Lively told Sony that she and the rest of the cast would not participate in any marketing or promotion alongside Baldoni, deliberately creating the false impression that Baldoni, and not that bitch, had committed some serious offense. Fact 158 to 161. On information and belief, Sloan was throughout this time working to spread false and defamatory allegations against Wayfarer parties to members of the press. Fact 187. I gotta do some self-massage in this bitch. The Wayfarer parties finally stood up to Lively and Reynolds and refused their final demand that the Wayfarer parties put out a false and humiliating statement admitting wrongdoing. Fact 250 to 256. Put my hair up. In response, Lively and the Sloan parties worked with the New York Times to concoct a story that would blame Lively's downfall on the Wayfarer parties heavily relying on deceptively spliced private text messages stolen from Abel's phone by her former employee and fresh enemy and Baldoni and Wayfarer's former publicist, Stephanie Jones of Joan Works, LLC. Fact 246. This shit's making me thirsty, yo. Like Blake was thirsty for Justin. And we are thirsty for justice for Justin. Right? The New York Times coordinated its publication with Lively's filing of the otherwise confidential CRD complaint on December 20th of 2024, fact 261-266. As a direct result, the Wayfarer parties have suffered untold harm, fact 299. The article states that during production of the film, Lively had complained that Heath and Baldoni had repeatedly violated physical boundaries, made sexual and other inappropriate comments to her. Art at 3. I think my bunny needs a little juice. Happy Saturday. Hey, sweet peaches. It is now Saturday, March 15th. Oh, look, it's 1:22 at 22 seconds. Well, now it's moving on. So I actually got really tired and I was like fumbling through reading it, and I decided to listen to it on my AI reader on naturalreaders.com. I paid for the whole year for a premium so I can get AI voices. This is not sponsored, although I should start back with my affiliate links. But anyway, so some people don't like AI reading. I paid for it because I use it all the time to listen to stuff, but also because when I record, I could not stand those low quality AI voices. They give me like a terrible headache. So I think these voices are, they're not completely realistic, but they're better than some. Plus, it was over an hour total. There was pretty much an hour left. A few times I speeded up because it just was like going to take forever. But I listened to the whole thing, I screen recorded it, and then I saved it so that you can see the words and listen to it. And before I get into that, I want to just say a few things, a couple of points that I was going to make a 20-minute video. And then I said, you know what? It's like 2 brief points. I can make them really quick. The first one is that Leslie Sloan believes that she should be dropped from the lawsuit and that she was entitled to use Blake Lively's words as if they were factual. And that's just simply not true. So just know that if somebody comes and tells you something about someone, say person A tells you person B did XYZ, and that XYZ thing is illegal and problematic, before you go repeating to somebody else, hey, person B did XYZ, and that shit is illegal. You need to check your sources. You need to get evidence. Or you could say, hey, person A told me that person B did XYZ, but that's their opinion. I didn't see any facts or evidence. That's their alleged opinion. They are alleging, person A is alleging that person B did XYZ, but everyone is innocent until proven guilty, so let's wait for some facts. That's very different than saying, oh my God, did you hear that person B did XYZ to person A? That is so effed up. And she thinks Leslie Sloan is claiming to the court, hey, that's what Blake told me. So I am totally within my rights to say that Justin Baldoni sexually assaulted or sexually harassed her. because she said he was kissing her without her consent and touching her without her consent. That's sexual assault. So that's what she told me. So I can go to say it. No. Then the second point that I was going to make was just I'm frustrated by hearing multiple sources repeat this idea that Blake is in the driver's seat in this, and that Blake can decide to settle. I've heard some people saying like, well, Justin needs to settle, or they have to settle this. Like, to me, it seems as if Justin is the one who has the evidence on his side, who has every reason to take this to trial to show the court and the jury the evidence so they can decide in the court of law. Because the court of public opinion is fickle and that does not pay your bills. And the court saying you are absolutely not liable for this, she is liable for this, she lied, she defamed you, she said you did things you didn't do, and you were smeared by her and her team. That is very different than him settling a case, which is almost always confidential, and then you don't get to see all the evidence, you don't get to hear voicemails, read text messages, read emails, whatever the case is, watch the videos. You don't get to hear from the witnesses. You don't get to depose the witnesses. I'm going to continue with what I was doing last night, which was using my massage balls. I have a lot of work to do on the computer today. So those are the 2 points that I wanted to make before I get back into the AI version of the rest of that document. Well, so those are the points that I wanted to make and add to this video. So if you're interested in hearing every word of the document, is a 36-page document, and this audio AI is going to start. It's going to pick up from where I left off. So I think I do start back at the top of, the last heading. So enjoy. Oh, and before I go, let me not forget to say, don't forget to hit like, hit subscribe. That will help my channel grow. My channel is a small channel. However, if you like the work that I'm doing and the videos that I'm putting out, I would love it for you to join me. Hit subscribe for free. You can also join me on Patreon. You can join me on Patreon for free, or you can join as a paid member, which will help support the work I'm doing here. Or you can join as a member on YouTube. And so I got a new client. I'm going to be working a lot of the week during the day on stuff for her. And so if you love the videos and you want me to be able to have more time to make more videos, then your support is priceless. Thank you. And now we can listen to the rest of the document. See ya. Filed by Attorney Jason Sunshine in opposition to the motion to dismiss this first amended complaint.
Legal standard under Rule 12b-6 of the Federal Rules of Civil Procedure. A plaintiff must state enough facts to state a claim to relief that is plausible on its face. Bell Atlanta Corp. v. Twombly, 550 U.S. 544, 570, 2007. A claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Ashcroft v. Iqbal, 556 U.S. 662, 678, 2009. In ruling on a motion to dismiss, the court must accept the factual allegations as true, drawing all reasonable inferences in favor of the plaintiff. Koch v. Christie's International plc, 699 F.3d 141, 145, 2d Sire 2012. Argument I. The NYT has ample notice of ITS Actionable Conduct Rule 8 of the Federal Rules of Civil Procedure imposes a lenient standard for pleading. Winder v. McMahon 360 F.3d 73, 80, 2d Sire 2004. Under Rule 8, a pleading need only contain a short and plain statement of the claim showing that the pleader is entitled to relief. Federal R. Civ. P. 8a. 2. Specific facts are not necessary. The pleading need only give the defendant fair 5 case 1:24 CV10049 oval document 127 filed 03/14/25 page 16 of 36 notice of what the claim is and the grounds upon which it rests. Erickson v. Pardis, 551 U.S. 89, 93, 2007. The Second Circuit has noted that Rule 8 does not necessarily require that the complaint separate out claims against individual defendants. Winder 360 F.3d at 80. Nothing in Rule 8 prohibits collectively referring to multiple defendants where the complaint alerts defendants that identical claims are asserted against each defendant. Manchanda v. Navient Student Loans, 2020 WL 5802238, at 2, Est.NY September 29, 2020. Point 2. The FAC gives the NYT adequate notice of the claims against it. The FAC alleges that the NYT conspired with Lively, Reynolds, Sloan and Vision PR to advance a false and defamatory narrative concerning the Wayfarer parties, ultimately coordinating a near-simultaneous drop of the article, video and CRD complaint. The allegations in these 3 documents fall into 2 principal categories. 1. Allegations that certain of the Wayfarer parties engaged in sexual misconduct towards Lively. And 2. Allegations that the Wayfarer parties orchestrated a retaliatory, smear campaign to damage Lively's image and reputation after she purportedly reported their alleged misconduct. Those allegations are false, and the NYT either knew they were false or acted with reckless disregard as to their falsity. To the extent the NYT is grouped in parts of the FAC with other consolidated defendants, that is because, as alleged in the FAC, they conspired in secret over a matter of months. The precise contours of the NYT's involvement were carefully concealed and impossible to ascertain fully without discovery. FAC 263. The FAC alleges that the NYT participated actively in the legal maneuvering at the heart of Lively's strategy. FAC 260, and with an articulated basis in fact, that the coordination began as early as October 31, 2024. Fact 268, noting references in the article's HTML source code to October 31, 2024 and alleging that the NY had already begun building the article no later than that date. 2. See also Van Toon P. By Co vs Yangpu NGT Industry Co., 2015 WL 4040882, at 3, Est.NY July 2, 2015. 1 West Bank NAV. Lehman Brothers Holding Inc. 2015 WL 1808947, at 3, Est.NY April 20, 2015. 6 Case 1:24 CV10049 oval document 127 filed 03/14/25 page 17 of 36. The cases cited by the NYT are inapposite. TheCheck.com Mul CV. NEMC FinServes. JRP. Inc. 2017 WL 2627912 at 1 S. DNY June 16, 2017. Concerns motions for entry of default judgment where the plaintiff failed to differentiate between defendants and attributed no specific conduct to any of them individually. ID. At 3. See also Achuahin v. City of Hartford 10F Apex. 33-34, 2D CIR 2001. Affirming dismissal of complaint lacking any differentiation between defendants or identifiable factual basis for claims despite multiple amendments. Similarly, the pleadings at issue in Komatsu v. City of New York, 2021 WL 3038498, at 6, Est.NY July 16, 2021, raise approximately 200 claims against 125 defendants, spread across 1,713 pages. Any lack of differentiation in the FAC does not rise nearly to those extremes. 32. California law applies to the way.
First of several, speeding up, gotta get through this thing, it's gonna take forever.
Any lack of differentiation in the FAC does not rise nearly to those extremes. 32. California law applies to the Wayfarer parties' claims in diversity cases. Federal courts apply the choice of law rules of the forum state. Gilbert v. Seton Hall University, 332 F.3d 105, 109, 2D CIR 2003. The choice of law rules of New York therefore apply. Press versus Primavera 685F. Sup. 3D 216, 225, NY 2023. The first step is to evaluate conflicts between New York and California law. Kessner versus Dow Jones & Co. Inc. 515F. Sup. 3D 149, 167, NY 2021. A conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly. Horton versus Greenwich Hosp. 2014 WL 956468, at 2N.1, SY March 10, 2014. Here, there exist substantive conflicts between the laws of New York and California as to the Wayfarer parties' claims against the NYT. As to false light invasion of privacy, for the conflict between the two states' laws is total. California recognizes the claim while New York does not. 5.3 If the court finds some merit in the group pleading argument, it should afford the Wayfarer parties leave to amend. Notably, even the plaintiff in Komatsu was granted leave to replead. Komatsu 2021 WL 3038498 at 6. For although the false light invasion of privacy claim is personal to and brought only by Baldoni, Heath, Nathan, Abel and Sarowitz for simplicity's sake, the opposition refers to the claim as brought by the Wayfarer parties. 5 Compared to Haviland v. FX Networks, LLC 21 Calories App. 5th 845, 865, 2018. A false light claim like libel, 7 Case 1:24 CV10049 Algol Document 127 Filed 03-1425 Page 18 of 36 There are also important differences with respect to the defamation claim. For example, with respect to defamation, California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. Condit versus Dunn, 317F. Sup. 2D 344, 352, SNY 2004. Because there is a substantive conflict between the laws of New York and California as to the Wayfarer parties' claims, the court must analyze whether to apply New York or California law. 6 In defamation cases, New York applies the law of the state with the most significant interest in the litigation. Condit 317F. Sup. 2D at 352, quoting Lee v. Bankers Trust Co., 166 F.3D 540, 545, 2D CR 1999. Under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. Lee 166 F.3D at 545, quoting Reeves v. American Broad. Co. 719 F.2D 602, 605, 2D CR 1983. See also Bricks v. Canadian Broad. Corp. 928 F. Sup. 381, 383, SY 1996. Collecting. Cases. Although the preference for the plaintiff's domicile is not conclusive, the significant contacts in a defamation case are almost exclusively the parties' domiciles and the locus of the tort. Lee 166 F.3D at 545, quoting Aerochem International, Inc. v. Burkle, 968 F.2D 266, 270, 2D CR 1992. The interest of a state in a defamation action is significant and incontrovertible, where the plaintiffs are citizens of that state and live and conduct their business there. Adelson v. Harris, 973 F. Sup. 2D 467, 477-78, Eston 2013. Exposes a person to hatred, contempt, ridicule, or obloquy and assumes the audience will recognize it as such. With D. Julius v. Engel 2021 WL 4443145, at 9, Eston September 27, 2021. New York does not recognize the tort of false light invasion of privacy. Citation omitted. 6 Each claim's choice of law is analyzed separately. Delius 2021 WL 4443145, at 4. New York follows the doctrine of deprecage, under which the choice of law analysis is conducted separately for each individual claim. 8 Case 1:24 CV10049 Aljol Document 127 Filed 03/14/25 Page 19 of 36 In this case, California has a significant interest because nearly all of the plaintiffs 7 are residents of California. The 2 corporate plaintiffs are both incorporated and/or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California. 8 And the economic losses to the plaintiffs were all felt in California. La Luna enters. Inc. v. CBS Corp. 74F. Sup. 2D 384-389, SNY 1999. Reeves, 719F.2D at 605, applying California law, since the state of the plaintiff's domicile will usually have the most significant relationship to the case. Here each of the wayfarer parties lives, works and/or maintains social relationships in California, and the law of California should therefore apply. Moreover, as participants in Hollywood's entertainment industry, the beating heart of which is indisputably the state of California, the wayfarer parties' reputations mattered most in California. Condit 317F. Sup. 2D at 354, plaintiff congressman's reputation necessarily was a matter of national significance, but it mattered most in California where he had been elected to office. The NYT argues that New York law applies because the article emanated from New York, i.e., entirely reported from and conceived in New York. However, the FAC itself does not allege that the article is based on information provided in New York by individuals residing in New York to reporters in New York, ECF number 106 at 8, and discovery will be needed to reveal, among other things, precisely where the NYT's reporting took place. Furthermore, the FAC does not say, as the wayfarer parties do not yet know, where the content was uploaded or where the relevant server resided, much less that either event occurred in New York. Nunes vs. Cable News Network Incorporated. 31F.4th 135, 142, 2 DCIR 2022. To the extent the NYT has attempted to introduce 7, the only non-Californian plaintiff is Steve Sarowitz of Illinois. No party has yet argued the law of Illinois should apply in this action. Moreover, Sarowitz's connection to this action is through his ties to California-based Wayfarer. 8. The FAC alleges that the Wayfarer parties also suffered injury in New York as well as in their home state of California, which is a true statement though the bulk of the harms were felt in California. To the extent that additional allegations are necessary to cure any inartful pleading as to the primary location of the harms, the court should grant leave to amend. Pursuant to the extremely liberal standard of Federal R. Civ. P15A. 2. 9 Case 1-24 CV10049 Aljol Document 127 Filed 03/14/25 Page 20 of 36 Ostensible evidence via declaration of counsel about the article and videos purported New York nexus. Consideration of such materials outside the pleadings is inappropriate on a motion to dismiss. ID. Rejecting argument that New York law applies to defamation claim against CNN because it is unsupported by the allegations of the complaint, to which the court is limited on a motion to dismiss, and refusing to consider purported evidence in defendants' affidavits. Even if, as the NYT contends, its reporting and defamatory statements emanated from New York. Imply because the defendant issues its nationwide publication from its principal place of business in New York does not mean that courts should automatically apply New York law to key dispute. Sackler vs. American Broadcasting Companies, Inc. 2024 WL4041715, at 4 New York Sup. CT September 4, 2024. In Sackler, a plaintiff brought a defamation claim against the publisher of the New York Post arising from the publication's misuse of plaintiff's photo in an online article. ID at 1. The Sackler court explained that the New York choice of law principles point not to the act as the locus of the tort but instead to the injury, which is the final element that would make the defendant liable. ID at 4. The Sackler court found that the defendant's nationwide publication of his photograph had the greatest effect, to the plaintiff and his overall reputation in the state where he resides. ID. At 4. Rejecting application of New York law and applying law of plaintiff's state of residence, New Jersey. This reasoning applies here, particularly given that the defamatory statements were published primarily via the Internet. 9 Adelson 973 F. Sup. 2D at 480-81. It is quite foreseeable that the brunt of the reputational harm that results from internet-based defamation is most likely to be felt in the forum where the defamed individual lives, works, and maintains social relationships. Quotation omitted. 9. Notably, according to NYT itself, of its approximately 11 million total subscribers in 2024, nearly 10.5 million subscribers were to digital products only, leaving only around 500,000 subscribers for NYT print newspaper. See https www.newyorktimes.com 2024 1104 Business Media New York Times Earnings.html 10 Case 1:24 CV10049 Ogle Document 127 Filed 03/14/25 Page 21 of 36 2 cases the NYT discusses and relies on, Jacob and Kinsley, are inapplicable. The courts in both those cases noted that the defamation claims emanated from New York. Jacob v. Lorenz 626 F. Sup. 3D 672 685, SDY 2022. Article emanated from New York. Kinsey v. New York Times, 991 F.3D 171, 178, 2D CIR. 2021. Defamatory statement emanated from New York. Here, other than alleging that the NYT is a corporation with a principal place of business in New York, FAC 311, the FAC is silent on where the NYT's reporting took place and where the article and video emanated from. Regardless, California has a far more powerful interest in the application of its law than the states at issue in Jacob and Kinsley because this case involves not only California residents but also Hollywood's entertainment industry, which is centered in California and is the source of employment of all of the parties in these proceedings. Indeed, the article's title refers to a Hollywood smear machine, in recognition of subject's intrinsic connection to California's entertainment industry. By a wide margin, California's interest in having its laws apply to this dispute outweighs that of New York. The article is also purportedly based on reporting concerning Lively's CRD complaint filed in California which purported to assert claims under California's employment and labor laws. FAC 4, 262. The NYT also glosses over the fact that filming took place not in New York but in New Jersey, which is where Lively alleges most of the events took place. FAC XA at 51. In short, the laws of California can and should supply the remedy for harms suffered primarily in California by plaintiffs who all live, work, and/or do business in California, resulting from conduct aimed at California, all in connection with the entertainment industry centered in California. 3. The Wayfarer parties' claims should not be dismissed. A. The defamation claim should not be dismissed. 11 Case 1:24 CV10049 Ogle Document 127 Filed 03/14/25 Page 22 of 36 California recognizes two types of libel, per se and per quat. See Bartholomew v. YouTube, LC, 17 Calories App. 5th 121 12/26 2017. Discussing distinction between libel per se and libel per quat. A statement is libel per se when it is defamatory of the plaintiff without the necessity of explanatory matter, such as an inducement, innuendo, or other extrinsic fact. Calciv. Code 45A. Whether a publication is libelous on its face is a question of law. Freeman v. Mills, 97 Calories App. 2D 161, 165-66, 1950. Publication is to be measured not so much by its effect when subjected to the critical analysis of a mind trained in the law, but by the natural and probable effect upon the mind of the average reader. A defendant is liable for what is insinuated as well as for what is stated explicitly. Bartholomew 17 Calories App. 5th at 1227, citing McLeod v. Tribune Publishing Co. 52 Calories 2D 536, 547-48, 1959. 10 False allegations of sexual misconduct are defamatory per se. The crux of the article and video is that the Wayfarer parties engaged in and/or condoned sexual misconduct and took revenge on the victim of such misconduct. These allegations tend to expose the Wayfarer parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them in the minds of right-thinking persons, and to deprive them of friendly intercourse in society. Sydney, 242 New York at 211-12. As to IEWU and Wayfarer, it is well settled that a statement that impugns the basic integrity of a business is per se defamatory. Boole v. Hutton, 328 F.3d 84, 94, 2d CIR 2003. 11. And contrary to the NYT, it is clear that the
Speeding it up a bit, a little faster.
11. And contrary to the NYT, it is clear that the defamatory 10 the same is true under New York law. A statement is actionable without alleging special damages if it tends to expose the plaintiff to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of him in the minds of right-thinking persons, and to deprive him of their friendly intercourse in society. Sidney v. McFadden Newspaper Pub Corp., 242 New York 208, 211-12, 1926. 11. The Wayfarer party's allegations also implicate the small group exception of the group libel doctrine. Under the group libel doctrine, typically, a statement made about an organization is not understood to refer to any of its individual members unless that person is distinguished from other members of the group. 3. Amigos SL Rest. Inc. v. CBS News Inc. 15N.Y.S.3d. 3641 First Step 2015. Aft 28N.Y.3d. 82, 2016. But where a statement defames all members of a small group, the reference to the individual plaintiff reasonably follows from the statement. Brady v. Ottaway Newspapers, Inc. 445N.Y.S.2d. 786, 790, 2d Dept 1981. Accordingly, an individual belonging to a small group may maintain an action for individual injury resulting from a defamatory comment about the group, by showing that he is a member of the group. ID. See also Algarin v. Town of Wallkill, 421 F.3d 137, 139-12 Case 1:24 CV10049 Aljol Document 127 Filed 03-14-20.
A little bit faster now. Gotta get through
See
this.
also Algarin v. Town of Wallkill, 421 F.3d 137, 139-12 Case 1:24 CV10049 Aljol Document 127 Filed 03-14-25 Page 23 of 36 statements made by the NYT in the article and video were of and concerning each of the Wayfarer parties, either directly by implication, and all have become figures of infamy as a direct result. 12 Blatty v. New York Times Co. 42 Calories 3D 1033, 1043, 1986. Because this is not a case in which a jury would be incapable of finding that the statements at issue refer to each of the Wayfarer parties, the NYT is raising a question of fact for the jury and not a question of law for the court. C. Diaz v. NBC Universal Inc. 536 F. Sup. 2D 337 343 Aft 337 Federal Acts. 94, 2D CIR 2009. Jury generally decides whether defamatory statement is of and concerning plaintiff. 1. The fair report privilege does not apply to protect the NYT. For the fair report privilege to apply under California law, the publication at issue must 1. Report on the contents of a judicial or other public proceeding. 2. Be a fair and true report of the proceeding. And 3. Be published in or made to a public journal. Calcif Code 47, D. A publication is fair and true under Section 47D, only if it captures the substance of the proceeding as measured by the natural and probable effect on the mind of the average reader. Kilgore v. Younger 30 Calories. 3D 770 777 1982. Murray v. Bailey 613 F. Sup. 1276 1284, ND Cal 1985. See also Hayward v. Watsonville Register Pageronian and Son, 265 Calories App. 2D. 255, 262, 1968. A report is not fair and true if the publication deviates from the judicial proceeding such that it produce a different effect on the reader than the actual truth of the proceeding. Crane v. Arizona Republican, 972 F. 2D. 1511-1519 9th Circle 1992. Quoting Hayward 265 Calories App. 2D. At 300. Here the privilege can apply only if the effect on the readers and listeners of the 2D CR 2005. Church of Scientology of California v. Flynn, 744 F.2D 694, 697 N.5, 9th Circle. 1984. Ball v. Taylor 416 F.3D 915, 8th Circle 2005. Per curiam. Finding small group exception applied where statement defamed approximately 100 individuals. 12. Although the NYT now argues its statements did not implicate Sarowitz, it is telling that TUI reached out to him for comment along with the other Wayfarer parties before publication. She clearly was not of the belief that the article and video did not implicate him personally. 13 Case 1:24 CV10049 Will Document 127 Filed 03/14/25 Page 24 of 36, article and video, would have been substantially the same as the effect on the readers of the CRD complaint itself. Colt vs. Freedom Calmer, 109 Calories App. 4th 1561-1561, 2003. 13 In the article and video, the NYT offers its own commentary that goes well beyond merely reporting on the CRD complaint and therefore falls outside the scope of the privilege. See Lyon vs. Fairweather, 63 Calories App. 194-197 1923, Section 47D, does not include as privileged facts outside the record or comments by the writer. For example, in both the article and video, the NYT presented as unquestioned fact the false and defamatory claim that the Wayfarer parties orchestrated a smear campaign. See FAC 257, 266-267, Art. At 3 Video TR. At 3-4 the NYT cites to thousands of pages of documents it had reviewed, and claims that the text messages show that the Wayfarer parties had engaged in the wrongdoing of which Lively accused them. Video TR. At 3:6-7, private text messages and other documents that the NYT obtained reveal what really happened. These extraneous comments and defamatory allegations, at least one of which the NYT admits was not taken from the CRD complaint, ECF number 106 at 15, are not a report of the CRD complaint and undoubtedly would produce a different effect on the reader than would the CRD complaint. Crane, 972F, 2D. At 1519, see also Colt 109 Calories App, 4th at 1561. Thus, they fall outside the bounds of California's fair report privilege. CEG Heitkoetter vs. Dom, 2024 WL 325134 at 11 ED Caljan. 29 2024. Holding fair report privilege did not apply to the portions of the defendant's video that consisted of tangential commentary, since it deviate substantially from reporting on his counterclaim, and produce a different effect. 13C also restatement 2nd, of torts 611 CMT. F. 1977. Not only must the report be accurate but it must be fair. Even a report that is accurate so far as it goes may be so edited and deleted as to misrepresent the proceeding and thus be misleading. Thus, it is necessary that nothing be omitted or misplaced in such a manner as to convey an erroneous impression to those who hear or read it. The reporter is not privileged under this section to make additions of his own that would convey a defamatory impression, nor to impute corrupt motives to anyone, nor to indict expressly or by innuendo the veracity or integrity of any of the parties. 14 Case 1:24 CV10049 Will Document 127 Filed 03/14/25 Page 25 of 36 on the listener. Goldberg v. Teach BK Incorporated. 2025 WL 296143, at 14, ND Cal January 24, 2025. Holding defendant's statements that plaintiff leaks her client's information to the Russian government and is a double agent, were not privileged as a fair and true report of a judicial proceeding. 14 The NYT vouched for Lively's allegations by affirming that its reporter's independent investigation supported her claims, and thus lost the protection of the fair report privilege. Heitkoetter 2024 WL 325134 at 11, Wilbank 121 Calories App. 4th at 904 to 5.15 Whether the NYT's publications are fair and true accounts of the CRD complaint are questions of fact that cannot be resolved at this stage. CEG Pierce vs. San Jose Mercury News, 214 Calories App. 3D 1626, 1634, 1989. Whereas here reasonable minds could disagree on what is fair, the issue is a question of fact to be determined by the jury. 16.2. The NYT's statements are not constitutionally protected opinions under California law. To constitute defamation, the offensive publication must consist of statements of fact, not opinion. Summit Bank vs. Rogers, 206 Calories App. 4th 669, 695-96, 2012. A statement is defamatory only if it is capable of being proved true or false. C. Savage vs. Pacific Gas and Electric Co., 21 Calories App. 4th 434-445, 1993. Jensen v. Hewlett-Packard Co. 14 Calories 14 Wilbank vs. Wolk, 121 Calories App. 4th 883-904-05 2004. Section 47. Did not protect defendant where statements were more than a report of an official proceeding. They were express and implied assertions that plaintiffs were incompetent and unethical. Crane 972 F2D. At 1519 Fair report privilege inapplicable as editing altered tenor. 15 The same outcome would be reached under New York's fair report privilege codified in New York Civ. Rights Law 74. Carroll vs. Trump, 664 F. Sup. 3D 550, 558-60, Est NY 2023. If the challenged portion of the publication focuses exclusively on underlying events rather than a judicial proceeding relating to those events, is commentary on the proceeding, or sets forth additional facts not established in the proceedings, the privilege does not apply. See also Greenberg v. Spitzer, 155A.D.3d. 2749 2017. Reversing trial court's application of the privilege as to statements that went beyond merely summarizing or restating the proceedings because, when viewed in context, we cannot say as a matter of law that the statements provided substantially accurate reporting of the case. 16. See also Nunez v. NBC Universal Media LC, 643 F. Sup. 3D 403-413, S. DNY 2022. Application of the fair reporting privilege is inappropriate at the motion to dismiss stage if a reasonable jury could conclude the report suggested more serious conduct than that actually suggested in the proceeding. Carroll 664 F. Sup. 3D at 562. The court need not decide the ultimate issue of whether the statement is or is not a fair and true report of a judicial proceeding as a matter of law. It suffices for the purpose of denying summary judgment that a reasonable jury could find so as a matter of fact. 15 Case 1:24 CV10049 LJL Document 127 Filed 03-1425 Page 26 of 36 App. 4th 958, 970-71, 1993. Statements do not imply a provably false factual assertion and thus cannot form the basis of a defamation action if they cannot reasonably be interpreted as stating actual facts. Seelig v. Infinity Broad Corp. 97 Calories App. 4th 798, 809, 10, 2002. But expressions of opinion often imply assertions of fact and are therefore actionable. Weller v. American Broadcasting Companies, Inc. 232 Calories App. 3D 991, 999, 1991. Thus, a statement in the form of an opinion may be actionable if it is implied that it is based on some undisclosed defamatory facts. Baker v. LA Herald Examiner, 42 Calories 3D 254, 266, 1986. Oken v. Superior Court, 29 Calories 3D 442, 451-52, 1981. The issue of whether the statement is fact or opinion is one for the jury. Slaughter v. Friedman, 32 Calories 3D 149, 154, 1982. The dispositive question is whether a reasonable fact finder could conclude that the published statements imply a provably false assertion of fact. Moyer v. Amador Valley Joint Union High School District, 225 Calories App. 3D 720, 724, 1990. To answer that question, the court applies a totality of the circumstances test and reviews the language of the statement and the context in which the statement was made. Baker 42 Calories 3D at 260-61. 17 Here, the NYT made statements that the Wayfarer parties engaged in, permitted and or failed to prevent sexual misconduct and orchestrated a smear campaign in retaliation for Lively's purportedly protected disclosure thereof. Fact 257, 266-267, 272, 274-275. Furthermore, the NYT asserted not only that the Wayfarer parties engaged in a smear campaign, but also stated 17 similarly, courts applying New York law generally consider 1. Whether the specific language and issue has a precise meaning which is readily understood. 2. Whether the statements are capable of being proven true or false. And 3. Whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Goldfarb v. Channel 1 Russia, 663 F. Sup. 3D 280, 302, SDY 2023. But even opinions can be the subject of a defamation claim where they imply that they are based upon facts which justify the opinion but are unknown to those reading or hearing it, i.e., a mixed opinion. Conklin v. Lakeson 180A.D.3d. 1358-1361 4th Dep 2020, citation omitted. Conti v. Doe 535 F. Sup. 3D 257, 267, SDY 2021. Ultimately, he dispositive inquiry is whether a reasonable reader could have concluded that the statements were conveying facts about the plaintiff. Gross v. New York Times, 82N.Y.2d. 146, 152, 1993. 16 Case 1:24 CV10049 Oval Document 127 Filed 03-1425 Page 27 of 36 in the article's title that the Wayfarer parties operated, or were a part of a Hollywood smear machine. FAC 261. The NYT's assertion that the Wayfarer parties operated a smear machine that waged a smear campaign was a factual statement that went beyond even Lively's allegations in the CRD complaint, which does not contain these phrases. The article claimed to expose the existence of a hidden nefarious machine devised by the Wayfarer parties that wages undetectable smear campaigns to destroy its enemies. The NYT statements imply misconduct on a scale larger than that at issue in the CRD complaint and are not immune from suit as opinion. Treple vs. BioVale Corp. 2005 WL2086339, at 10 SNY August 30, 2005. Denying 12b. 6. Motion to dismiss defamation counterclaims based on statements that suggest wrongdoing on a scale larger than would be disowned from reports of a regulatory investigation. The article's false assertion of a smear campaign suggested the NYT was making a factual statement. Black's Law Dictionary, 12th edition 2024, defines the phrase smear campaign as deliberate telling and repetition of untrue or distorted stories about a person in order to make others lose respect for that person. The phrase is inherently factual in that it suggests that a person waging such a campaign is spreading stories that are untrue or distorted. The cases cited by the NYT are again entirely inapposite. In the New Hampshire case of Pease vs. Tell. Pubco 121 NH62 1981, a journalist brought a defamation claim arising from a letter to the editor in which defendant prefaced two of his assertions with language such as, "I do feel," and coupled his statement of a journalistic smear with the epithet that the plaintiff was the holder of the title, journalistic scum of the earth. ID at 64 to 65. The Pease court concluded that readers would interpret the writer's hyperbolic statements as opinion rather than as assertions of provable fact. ID at 65. None of the other cases cited by the NYT involved smear accusations. In Dong vs. Board of Trustees, 191 calories app. 3D 1572 1987, the statements at issue were preceded 17 case 1:24 CV10049 Ugal document 127 filed 03/1425 page 28 of 36 by qualifying language that the assertions were merely a claim and that a peer committee should investigate. In Greenbelt Co-op, Pub Association v. Bressler, 398 U.S. 6, 1970, the statement at issue was blackmail, and not smear campaign, as the NYT suggests. And in Chow vs. Lewis, 771 F.3d 118, 2D CR 2014, the defamatory statements were epithets such as sucker and fool. The statements at issue here were made not in an editorial or letter but rather in an explosive feature-length exposé reported by, among others, the NYT's Pulitzer Prize-winning star journalist Tui, based on their own review of thousands of pages of text messages and emails. Art. 2. The NYT statements in the article and video are not couched or qualified by equivocal language suggesting that the NYT or TUI were expressing an opinion. They were presented as statements of fact based on first-hand knowledge of the evidence. In that context, a reasonable viewer would have interpreted the NYT's smear machine and smear campaign statements not as mere hyperbole but instead as provable, verified assertions of fact. Statements of this nature are not shielded from suit as non-actionable opinion. 18. The NYT statements state or imply that the Wayfarer parties engaged in grossly immoral conduct to cover up even more grossly immoral conduct, and such statements resulted in the destruction of their reputations and careers. The statements by the NYT cannot be and were not construed as mere statements of opinion or of hyperbole. They were false statements of fact. And if the court finds that the statements could be reasonably construed as either fact or opinion, the issue should be resolved by a jury, thereby warranting the denial of the motion. Good Government Group of Seal Beach Incorporated. V. Superior Court, 22 calories 3D 672, 680, 1978. 3. Actual malice has been pleaded against the NYT. 18. To be clear, the allegations in the FAC are unequivocal that none of the Wayfarer parties engaged in any kind of misconduct towards Lively. The Wayfarer parties did not permit or fail to prevent any such misconduct. And the Wayfarer parties did not orchestrate a smear campaign in retaliation for Lively's purported disclosures. Fakopt, zeche, 278 285, 279, 281. 18 case 1:24 CV10049 Oval document 127 filed 03/1425 page 29 of 36. The NYT argues that the Wayfarer parties have to satisfy the actual malice standard because of Baldoni's status as a public figure and New York's amended anti-SLAPP law, New York Civ. Rights Law 76A. Though California and New York law diverge on whether the actual malice standard applies to all of the Wayfarer parties, it is irrelevant for present purposes because the FAC adequately alleges actual malice with respect to each of them. 19 To plead actual malice. A plaintiff must allege a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. Reader's Digest Association v. Superior Court, 37 calories. 3D 244 256, 1984. Citing New York Times Co. vs. Sullivan, 376 U.S. 254, 285 to 86, 1964. See also Biro vs. Condé Nast, 807 F.3D 541, 544, 2 DCIR 2015. While reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity or entertained serious doubts as to the truth of his publication. Hart Hanks Conkiness, Inc. vs. Connaughton 491 U.S. 657, 667, 1989. See also St. Amant vs. Thompson, 390 U.S. 727, 731, 1968. Construed as true, the facts allegations set forth plausible grounds to infer actual malice. Biro, 807 F.3D at 546. Actual malice is subjective, but a court typically will infer actual malice from objective facts. Bose Corp. vs. Consumers Union of U.S., Inc. 692 F.2D 189, 196, First Circle 1982. Whether a defendant entertained serious doubts as to the truth of the statement may be proved by inference, as it would be rare for a defendant to admit such doubts. Aft 466 U.S. 485, 1984. This refers to evidence of negligence, motive and intent such that an accumulation of the evidence and appropriate inferences supports the existence of actual malice. Bose Corp. 692 F.2D at 196, emphasis added. 20 Actual malice is established. Rough the defendant's own 19. This is true despite the fact that 6 of the Wayfarer parties are certainly not even limited public figures. 20 Goldwater vs. Ginsburg 414 F.2D 324, 342, 2 DCR 1969. There is no doubt that evidence of negligence, of motive and of intent may be adduced for the purpose of establishing, by cumulation and by appropriate inferences, the fact of a defendant's recklessness or of his knowledge of falsity. 19 Case 1:24 CV10049 Wall Document 127 Filed 03-1425 Page 30 of 36 Actions or statements, the dubious nature of his sources, and the inherent improbability of the story, among other circumstantial evidence. Liberty Lobby Incorporated v. Dow Jones & Co., 838 F.2D 1287, 1293, D.C. Sierra 1988. C. Clyburn v. News World Comkiness, Inc. 903 F.2D 29, 33, D.C. Sierra 1990. Proof of actual malice may take the form of circumstantial evidence such as obvious reasons to doubt the veracity of the informant or the accuracy of his reports. Here it is not just that the NYT failed to adequately investigate, but rather that it did investigate and obtained and reviewed communications that disproved what it later published, and that it edited and spliced documents to mislead viewers. Fact 272 to 278, 283 to 287 Willfully disregarding, let alone manipulating, information casting doubt on a story is altogether different from negligently failing to investigate in the first place. See St. Amant, 390 U.S. at 733, citing Curtis Publishing Co. vs. Butts, 380 U.S. 130, 153, 1967. Where a publisher undertakes to investigate the accuracy of a story and learns facts casting doubt on the information contained therein, it may not ignore those doubts, even though it had no duty to conduct the investigation in the first place. Masson v. New Yorker Magazine, Inc. 960 F.2D 896, 901, 9th Circle 1992. In Masson, for instance, the court noted that there was evidence from which a jury could infer that the New Yorker investigated the facts underlying the article, including the quotations, and that this investigation yielded information that gave the New Yorker obvious reasons to doubt the accuracy of the disputed quotations. ID at 902. Likewise, in Hart Hanks, the Supreme Court affirmed an actual malice finding where the newspaper refused to listen to recordings or interview witnesses denying the allegations. Hart Hanks, 491 U.S. at 691 to 92. The NYT admits it did undertake an investigation. As alleged in the FAC, the NYT made clear that the article and video were not merely recitations of Lively's CRD complaint but were, instead, a work of independent investigative reporting. CEG FAC 266 to 267. Art. At 320 Case 1:24 CV10049 Algol Document 127 Filed 03-1425 Page 31 of 36. describing the Wayfair Party's alleged playbook for waging a largely undetectable smear campaign in the digital era. Video TR. At 3:5-7, describing private text messages and other documents that the NY obtained that reveal what really happened. As alleged in the FAC and conceded by the NYT, the substance of the reporting was based on thousands of pages of text messages and emails, which, along with other documents, were reviewed by the NYT. FAC 262. Armed with this voluminous evidence, the NY either knew or recklessly ignored proof that the contents of its article and video were factually false. FAC 274. The notion that Lively's bad press in August 2024 was actually caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. Church of Scientology International v. Behar, 238 F.3d 168, 174, 2d Cr 2001. Citing St. Amant 390 U.S. at 731. FAC 279-281. There were obvious reasons to doubt the veracity of these statements in light of the reporter's common sense, the NYT's prior reporting, and the relevant primary source documents and communications that the NYT obtained and that its reporters claimed to have reviewed. Curtis Publishing 388 U.S. at 158. Indeed, the NYT itself reported on Lively's public missteps in an August 17, 2024, article entitled, "It Ends With Us, The Press Tour Drama Explained." FAC 279. Not only were NYT reporters 21 privy to Lively's missteps in real time along with the world, they also reviewed private internal communications amongst the Wayfair parties directly refuting the article. Worse, the NYT worked on the article for many weeks before publishing, perhaps since October 2024. Fact 263-268. Yet the NYT deliberately waited until the last possible moment to seek a response from the Wayfair parties. 21. The NYT's argument concerning the fact's purported failure to attribute actual malice to specific individuals is unavailing. The FAC is laden with references to the article's principal author, Megan Twohey, and alleges that she and her co-authors, Mike McIntyre and Julia Tate, knew that what they were publishing was false and or recklessly disregarded the probability it was false by, at best, purposefully avoiding the truth. CEG, FAC 257-269. Twohey herself is featured in the video. 21 Case 1:24 CV10049 Eldrel Document 127 Filed 03-1425 Page 32 of 36 FAC 257-259. Indeed, on the evening of December 20th, Twohey contacted the Wayfair parties for a response by the next morning concerning explosive and false allegations. FAC 258. The Wayfair parties denied the allegations and specifically warned Twohey that her story was false and based on cherry-picked and context-free communications spliced into a provably false narrative. Fac 254. A publisher need not accept denials, however vehement, before publication. Hart Hanks, 491 U.S. at 691 N.37, citing Edwards v. National Audubon, Inc., 556 F.2d 113, 121. 2d Cr 1977. But here the NYT could verify the denials because it had purportedly reviewed those communications. Fact 257-259, 294-295. Purposeful avoidance of the truth supports a finding of actual malice. Hart Hanks, 491 U.S. at 692. 22. At this stage, the Wayfair parties have met their burden to plead facts giving rise to the plausible inference that the NYT published the allegedly defamatory article and video with actual malice. Palin v. New York Times Company. 940 F.3d 804, 815, 2d Cr 2019. The test is whether the complaint is plausible, not whether it is less plausible than an alternative explanation. The jury may ultimately agree with the NYT, but it is the jury that must decide. ID. B. The false light and promissory fraud claims should not be dismissed. False light is a species of invasion of privacy, based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. De Havilland v. FX Networks, LC, 21 Calories 22C. Also Aramo vs. Rolling Stone, LC, 209 F. Sup. 3D. 862, 872, WD Virginia 2016. Although failure to adequately investigate, a departure from journalistic standards, or ill will or intent to injure will not singularly provide evidence of actual malice, the court believes that proof of all three is sufficient to create a genuine issue of material fact. Houlihan vs. Worldwide Association of Specialty Programs and F.H. 2006 WL2844190. 5-6 DDC September 29 2006. Failure to further investigate biased and unreliable source with demonstrated animosity toward plaintiff provided an obvious reason to doubt the accuracy of the statements. 22 Case 1:24 CV10049 Aldol Document 127 Filed 03-1425 Page 33 of 36 App. 5th 845, 865, 2018. The FAC alleges the NYT falsely and recklessly accused the Wayfarer parties of orchestrating a smear campaign against Lively and purporting to reveal a new playbook for waging a far-reaching and largely undetectable smear campaign in the digital age. FAC 262, 267, 273-274. The FAC adequately states a claim for false light. 23 Under California law, elements of a promissory fraud action are 1. Misrepresentation, 2. Knowledge of falsity, 3. Intent to defraud, 4. Justifiable reliance, and 5. Resulting damage. Fuchs v. Vanatic 2024 WL94312, at 2 9th Circle January 9, 2024. Citing Lazar v. Superior Court, 12 Calories 4th 631-49, 1996. 24 Promissory estoppel is a subspecies of the action for fraud and deceit, in which a defendant makes a promise, inducing the plaintiff to enter into a contract, without the intention of keeping it. Lazar, 12 Calories 4th at 638. Here on the evening of December 20, 2024, the NYT promised to delay until noon the next day so the Wayfarer parties could respond to questions and inaccuracies. FAC 377. The Wayfarer parties accepted the offer and tried to correct the record, albeit in the context of a brief overnight window of time during the holidays. FAC 379. As alleged in the FAC, the NYT's outreach to the Wayfarer parties was a ruse. The NYT never intended the Wayfarer parties to respond. FAC 381. The NYT had already decided that the article and video would drop regardless of feedback from the Wayfarer parties, as shown by the fact that both the article and video were ready to go at least days before the NYT contacted the Wayfarer parties. FAC 259,267. Indeed, although the Wayfarer parties accepted the NYT's offer and scrambled to respond in just hours, the NYT published early and without warning at 7:11 a.m. PST. FAC 379-380. The 23 in a footnote, the NYT argues that if California law applies, the false light claim should be dismissed because the false light claim is independently barred by California's fair report privilege. ECF number 106 at 23 N.22. That argument fails for the same reasons as the NYT's challenge to the Wayfarer parties' defamation claim. 24 Accord E-Commission Sols. LCV. CTS Holdings Inc. 2017 WL9858881 at 5, Eston Y. March 13, 2017. Same elements under New York law. 23 Case 1:24 CV10049 Aldol Document 127 Filed 03-1425 Page 34 of 36 Release of the false article and video damaged the Wayfarer parties. Fuck those who knows it chopt, those who knows it know. The Wayfarer parties' promissory fraud and implied contract claims cannot be dismissed as duplicative. And a claim for promissory fraud does not depend on whether a defendant's promise is ultimately enforceable as a contract. Jacobs v. Sustainability Partners LLC, 2020 WL5593200, at 15, ND Cal September 18, 2020. Emphasis in original. As in Global Tax, which the NYT cites, the FAC does not just assert a contract the NYT did not intend to perform. It alleges conduct beyond the contract, namely that the NYT and the Lively parties conspired. Global Tax Derby. Ltd vs. Trends Sportswear Ltd, 2009 WL12700002, at 6, Eden Y. May 6, 2009. 25C. The breach of implied in-fact contract claim should not be dismissed under California law. A cause of action for breach of implied contract has the same elements as does a cause of action for breach of contract, except that the promise is not expressed in words but is implied from the promisor's conduct. Yari vs. Producers Guild of AM, Inc. 161 Calories App. 4th 172, 182, 2008. 26 Here the NYT does not and cannot argue that the FAC fails to properly allege the elements of a breach of implied in-fact contract. Instead, the NYT relies on certain outside the pleadings correspondence, improperly introduced through its counsel's declaration to supposedly contradict the facts allegations. ECF number 106 at 24. The NYT's attempt to raise and determine issues of fact on a Rule 12b. 6. Motion to dismiss is improper. 27 Nunez, 31 F.4th at 142, declining to consider evidence attached to affidavits on Rule 12b. 6. Motion to dismiss. Though the NYT claims that its promise to wait until noon to publish is 25, the NYT's unsupported and extrinsic assertion that the Wayfarer parties had no intention of doing anything in the 2 hours between the publication and deadline for comment, ECF number 106 at 24, not only raises a fact issue that cannot be adjudicated on a Rule 12b. 6. Motion, it is belied by conduct of the Wayfarer parties since, including filing the instant lawsuit and releasing voluminous exculpatory evidence. Global Text GRP. Ltd, 2009 WL1270002 at 6. 26 Accord Murray v. Samsung LX. AM. Inc. 83 Miscellaneous 3D 1290A. At 3 New York Sup. CT 2024. The elements are the same for a breach of a contract or implied contract under New York law. 27 The email correspondence attached to the declaration of Catherine Bolger, ECF number 107, is not referenced or incorporated into the FAC, and the mere fact that the FAC refers to other communications between the NYT and the Wayfarer parties does not permit the NYT to introduce purported evidence outside the scope of pleadings. 24 Case 1:24 CV10049 OL Document 127 Filed 03/14/25 Page 35 of 36 Nowhere seen or implied in the correspondence. ECF number 106 at 25. TUI's emails expressly state she need ed to hear back by noon Eastern, ECF number 107 X's. 4-9, thereby offering to give the Wayfarer parties until noon EST on December 21 to respond to the inflammatory allegations. 4. The motion should at most be granted with leave to amend. Granting leave to amend is consistent with the liberal standard of Rules 15. And with the Second Circuit's strong preference for resolving disputes on the merits. Patterson v. Morgan Stanley, 2017 WL115692335, at 2, Eston Y. September 27, 2017. This liberal amendment policy is applied to cases in which statements alleged to be defamatory were privileged under the fair report privilege, and when the requisite level of fault was inadequately alleged. 28-29 Conclusion The Wayfarer parties respectfully urge that the court deny the motion in its entirety. In the alternative, should the court be inclined to grant the motion in whole or in part, the Wayfarer parties respectfully request that they be granted leave to amend their pleading as stated herein. 3028 Cummings v. City of New York, 2020 WL882335, at 27, Eston Y. February 24, 2020, granting leave to replead. Defamation claim where fair report privilege applied. Jones v. Inner City Press, 2024 WL4403746, at 5, CD Cal August 7, 2024. Granting leave to amend claims including defamation claim where statements were subject to the fair and true report privilege. Mandel v. Haferman 503 F. Sup. 3D 946, 968-69, ND Cal. 2020. Granting leave to amend defamation claim though defendant met his burden of establishing that the litigation privilege applies to his conduct. Cassava Size, Inc. v. Brett, 2024 WL1347362 at 29, Eston Y. March 28, 2024. Granting leave to replead allegations of actual malice. 29 Though the Wayfarer parties have once amended their complaint, they have not done so in response to the purported deficiencies raised in the motion, which was filed after the FAC. Without the benefit of a ruling, many a plaintiff will not see the necessity of amendment or be in a position to weigh the practicality and possible means of curing specific deficiencies. Lorley Finn Jersey, No. 3 Ltd v. Wells Fargo ISI. LC, 797 F.3D 160, 190, 2 DCIR 2015. If any of the Wayfarer parties' claims against the NYT are dismissed, the Wayfarer parties respectfully urge that the dismissal be without prejudice and they be given leave to amend. 30 The Wayfarer parties incorporate by reference the contents of their opposition to the Sloan parties' motion to dismiss the FAC and strike Exhibit A. ECF number 121. 25 Case 1:24 CV10049 OL Document 127 Filed 03/14/25 Page 36 of 36 Dated March 14, 2025 New York Dated March 14, 2025 Los Angeles, California Respectfully submitted, Meister Selig and Fine PLC by S. Mitchell Schuster Kevin Fritz 125 Park Avenue, 7th floor New York.
There was one last minute, but it was all phone numbers, addresses, emails. I didn't think we needed to keep that. Join me at lovedreamingpeach.com.